Hello everyone in Kibri in Cameroon at this year's FICOTA conference. I'm very sorry that I cannot be with you. I really would have liked to. First, I saw a number of very impressive pictures from fashion made in Africa, and I would have loved to see what you're doing there. It also would have been nice to meet you all in person. And lastly, well, German weather is not really competitive. So it's rainy and pretty ugly in here, so I would prefer to be at a nicer place than at a beach. Still, I am glad that I am able to talk to you using this device, and I hope you will enjoy the presentation. My name is Hartmann. I work as Professor for Sustainability Management at EBS University of Business and Law, headquartered in Wiesbaden in Germany. So today I'm going to talk to you about the German Supply Chain Due Diligence Act, which has been passed a couple of months ago by the German government. And specifically, I would like to focus on what the requirements of the Act are for buying companies headquartered in Germany and discuss the implications for suppliers that are located around the world and including, of course, in Africa. So maybe a little bit about the background and why Germany has adopted such a regulation only recently. The main reason for this is that the United Nations have observed that a number of human rights violations continue to occur across the planet. These human rights violations are in part to be tackled by governments, both local governments, but also international regulatory institutions. But the problem is those governments cannot solve all problems. And in part, businesses are also relevant actors in the interplay of international economics and trade. So the idea is that if businesses are a player, they also have to contribute their share to the solution of those problems. So back in 2011, the United Nations issued a number of principles called the UN Guiding Principles on Business and Human Rights that were supposed to describe a number of general rules to be adhered to by individuals, organizations, and businesses around the globe. These principles are what they are. They are principles. So we call them soft law. Soft law means it is principles that those who are named in them should adhere to. But because they are not part of the regulation in a specific country, there are no sanction mechanisms if a company or an entity, an individual, does not comply. The UN guiding principles included a number of different principles, most of them actually targeting political institutions, but there are also a number of principles included in there that target organizations. Among those principles, principle number 13 is of specific interest. So principle number 13 has two sections, and I highlighted on this slide the second part of it, namely, businesses should seek to prevent or mitigate adverse human rights impacts that are directly linked to their operations, products, or services. So this means there is a principle saying that business enterprises should ensure that human rights are preserved not only within their own company's boundaries, but also among those parties whom an enterprise entertains relationships with. As I said previously, this is soft law. Soft law, again, means companies should comply, but they must not forcibly. And specifically, there's no opportunity to enforce compliance. What was the result of this? The result of this 2011 formulation of the UN principles basically did not change the business landscape to a large extent. A number of companies, but only very few, chose to change their supply chain management and procurement processes such that human rights and also environmental issues were included. But many of them did not. A recent survey dating back to 2019, which was done among German companies, came to the conclusion that less than 20% of all companies really adhere to this principle by implementing it thoroughly in their procurement processes. And this number hasn't increased since the year 2011. 20% is too little. What is more, implementing this regulation comes at a cost for firms which do this. These costs can be very different in form and quantity. So, for example, companies may need to change their IT systems to ensure that key performance indicators on social and environmental performance are included in those IT systems. But they would also need to hire personnel in order to be able to track suppliers' performance relative to those key performance indicators. So companies, the 20% which complied with the soft law requirement, felt that they are at a competitive disadvantage. Why this? Well, the main reason was they incurred the full costs of ensuring decent conditions in the supply chain, but they were not really able to benefit from these costs economically. It meant that they competed with other firms on the market, and these other firms did not encounter the same costs. Basically, that means your competitors can offer the same product at a lower price, or alternatively, you offer it as the same price of your competitors who do not incur the same costs, meaning that your profitability goes down. And all those factors led both political leaders in Germany, but also a number of companies to start to lobby for a regulation which would enforce all companies, no matter what industry, what size, etc., to pay attention to environmental and social conditions in their supply chain. They felt that this would ensure a level playing field. If everybody does it, everyone incurs the same costs, and then profitability of a few is not negatively impacted. Whether these ideas apply or not, in any case, the German government has adopted this Supply Chain Due Diligence Act in June 2021, so this year in the summer. And the regulation will become effective in the year 2023 for a number of companies, will actually then enlarge and include a number of more companies in 2024. Germany is, however, not the only country in Europe which has issued such a supply chain regulation. On this slide here, you see an overview of regulations that I have found. Yeah, so there is no guarantee for the completeness of this list. But as you can see, Germany is also not the first country that has issued such a regulation. The first country in continental Europe was actually the United Kingdom. The United Kingdom had adopted the so-called Modern Slavery Act back in 2015. Other countries followed. France, for example. France has a regulation that targets only really large companies. You see this here, the coverage is only companies that have more than 5,000 employees and that are headquartered in France. So that's only 120 companies. But the French law is also very strict because it includes a criminal liability clause, meaning that any company that is found not to be compliant with the so-called loi de vigilance can be sued in front of the courts. Other countries include the Netherlands, Switzerland, and Norway. So Germany is just one out of several European countries that have adopted a supply chain due diligence regulation. By the way, there is currently a debate within Europe to have a general European Supply Chain Due Diligence Act. If this act would be passed, it would mean that all countries that are members of the European Union would have to implement this into local or international regulation. So chances are very high that Germany will need to change its own supply chain due diligence regulation again in the future, depending on what the European regulation will look like. For the time being, however, the only regulation that is in place is the German one. And that is the one that we will focus on in the remaining part of this presentation. So what is the content of this regulation? The regulation targets companies that do business in Germany. That could also include companies that are headquartered elsewhere, but that have subsidiaries in Germany that meet the size criteria. So that have actually more than 3,000 or more than 1,000 employees. And the law prescribes that those companies need to define a policy about how they define human rights and how they and define a procedure, an accompanying procedure about how to communicate this policy statement to their suppliers. This is only a small part of the regulation. It's actually much more than this. Companies are also asked to do a regular risk assessment of all the categories, so products that they buy from outside markets. This risk analysis should not only include economic risks, but also social and environmental risks. Once this risk assessment is done, a company also needs to engage in risk management. Risk management basically means that companies need to define strategies about what to do with high-risk product categories, how to reduce the risk for those ones, and how to proceed if a risk actually materializes. So it's not only the assessment, it is also what to do with the results of this assessment. Beyond this risk management, companies also need to establish a grievance mechanism, which means that if somebody observes a violation in the supply chain, the buying company must have contact information on their website about whom to contact. And complaints should be it should be possible to make complaints in an anonymous way towards this company, as long as there is a decent reason to believe that this specific company is a customer to the company that the person who has observed or is affected by the violation, by this company. Buying companies also need to report regularly on their procedures, so what the outcomes of the risk assessments are, what the targets have been that have been defined for the risk management, and how targets have been attained or will be attained in the future. So basically which measures were taken. And if a company is alerted of a potential violation, it also needs to define clear steps as to how to either eliminate or reduce the risk. So it has to take corrective action. All of these risk assessment, grievance mechanism elements basically apply to the Tier 1 supply chain partners, so those suppliers who have an immediate contractual relationship with a buying company that has to be compliant with the Supply Chain Due Diligence Act. There are, however, also a few things that companies need to do with regard to their Tier 2 and beyond suppliers, so all the so-called indirect suppliers. And this includes if they have credible information that something went wrong at a sub-supplier's site, they need to engage in a verification process. So they need to assess if this information is really true or not, or if it is credible or not. And they need to define a strategy that is actually targeting, in this case, the indirect suppliers, not the direct suppliers, about how to solve or minimize the problems. Lastly, company also should establish prevention measures. Now, this regulation, of course, can only enforce compliance with buying companies that are here in Germany. But of course, this means that suppliers who deliver to those German buying companies also will be confronted with a number of challenges and requirements. So what is it that German buying companies will in future ask of their suppliers. Basically, the German Supply Chain Due Diligence Act, for the most part, targets human rights and tries to prevent human rights violations. But there are also a number of environmental concerns that the Act covers. So in terms of human rights, buying companies will in future ask for information and key performance indicators, documented proof, etc., that the following risks are not a problem in those supplier sites. Child labor and exploitation of children, forced labor and what we call modern slavery, work safety, that workers who work with machines are well protected, freedom of association, discrimination of people of different gender, different race, etc., that adequate wages have been paid, and that there is no unlawful use of security forces. So these are the things that buying companies need to ensure. And because this is what buying companies need to ensure, this is also what they will in future ask of their suppliers. Not only that they feel they are not affected by any of these, but really provide documents, certificates ideally, some sort of proof to ensure that these basic human rights are not violated. In terms of environmental preservation, the Act is not as thorough as it stands. So what is covered in here is direct environmental damage. So what this means is if you have toxic effluents, they should not be released into nature, so not into any rivers or into local land or something like this. In terms of certain substances like mercury, organic pollutants, and hazardous waste, the law requires that suppliers adhere to international general conventions and what is specified in those. So those conventions are the Minamata Convention, the Stockholm Convention, and the Basel Convention. And then lastly, a supplier should also have implemented sound processes to deal with wastes. So a question is here, how are wastes collected, stored, and disposed of? They should evidently not end up in any nearby woods. So the last question that I would like to address in this presentation is the question, how can you as suppliers located in Cameroon or in Africa in more general now benefit from this regulation that comes in anew to many German companies? So this year offers some benefits, in particular because it comes along with a specific situation, and that is the global pandemic, and hopefully its nearby end. So German companies across industries and including fashion have one big problem right now, and that is demand for products is skyrocketing. Basically, people have been locked down for a couple of months. They could not spend money and they could not travel, so they really like to go shopping these days. The second problem is a country or a region that Germans often buy from, namely Asia, is already running at overcapacity. So it doesn't matter if we speak about China, Taiwan, Bangladesh, and other countries located in Asia. All of these countries feel right now that they cannot satisfy European demand because there's such a huge demand, and there's also a huge demand from the United States. So that basically means that most European buying companies face long delivery times. They feel that they have been exposed to a very big risk because they have made themselves very dependent on a few suppliers located in Asia. And now it comes on top that they need to be compliant with the regulation as I just presented it to you. This is, I would say, a very unique chance and opportunity for companies that are located in Africa. they could now become suppliers to European companies that they might not have previously been a supplier for. So what does this mean for you? If you wanted to sell to Europe, how should you benefit from this window of opportunity? The first thing that I would suggest you to do is try to get documents that testify your compliance with what I have said before. So basically with the requirements of the German Supply Chain Due Diligence Act. If you can provide this documentation right away, it will ensure buyers that you are compliant with these specifications. Ideally, it would be best if an independent third entity could verify that these documents are actually correct and right, because that increases their credibility. Beyond this, what do you also have to do? Well, one key ingredient of success is you have to have a high so-called supply chain performance. What does this mean? There are basically 4 performance dimensions in supply chain performance. Price, of course, is one of them. Price has to be competitive, but also quality, delivery, and reliability. So in terms of quality, you really must document that the quality of the products is to the standards, usually as specified by the buying company. If you have agreed upon delivery deadlines, it is essential that delivery comes on time, because otherwise productions or continued production in Germany or sales is delayed, and that will harm the business of the buyers. And reliability, so once dates have been agreed upon, it is very important for the buyers in Germany that deliveries really come on time and are not delayed. A third element is digital infrastructure, if you wish. Most, or I would say all German buying companies have an IT system, and orders, communication with suppliers, anything, so invoices, it is all handled electronically. So it is very important that there is a good interconnection between both the suppliers and the buyers, such that any communication is not delayed. There are clear responsibilities, messages are seen, and there's also a response in terms of, yes, I have understood this is a question, I will clarify it, I will come back to you by X, Y, and Z. And then remember, reliability, also come back by date X, Y, and Z with a correct or with a response as promised. And then last element, I noted this one down here, is customs. That is something that I have heard in some conversations with buying companies here in Europe, by the way, from the fashion industry. And one of the big issues is that sometimes in order to produce a certain garment, you might actually import part of the fabrics. And sometimes these import procedures are very, very lengthy, and they negatively affect the other supply chain performance dimensions that we just talked about, delivery and reliability. So this is a very critical issue. If customs processes are lengthy, this has to be integrated into the planning process. Ideally, you should work with your local governments to make sure those customs processes are handled more swiftly and quickly. Well, that was it from my side. I think, or right now, I don't feel there's anything else to share. I hope you found this presentation helpful and are able to take something from it. I thank you very much for your attention, and I wish you an absolutely fantastic conference.